Good morning, everybody, and welcome to the first breakout session of AusCERT 2020. We get going, some basic housekeeping. Just make sure you use Chrome, and if the video freezes, just refresh the browser. Q&A will be available throughout the session using the Q&A section in the chat panel on the right-hand side. At the end of the session, if you did want to actually ask a live question on camera, use the raise hand button, and we'll be able to bring you to the stage to actually ask the question. So for our first session this morning, we've got Stefanie Luhrs and Ben DeMarco. Stefanie is currently a practicing solicitor specializing in cyber claims, working both in the privacy and incident response fields. And Ben is a reform solicitor working more in the GRC space. They'll both be discussing changes that have happened in Australia this year, both with the advent of COVID-19 and the increased risks of people working from home, but the introduction of CPS, Prudential Standard 234, the Information Security Standard. If everybody could welcome Ben and Stefanie, that'd be wonderful. Enjoy the session.
Thanks very much. Good morning, everyone, and thanks very much for tuning in. Ben and I will do another quick introduction shortly, but we're very pleased to be speaking to you today about this fascinating world of data and privacy risk in this new age that we find ourselves in. As most of you will know from a number of headline events in the last 12 months, the data and privacy risk landscape has changed significantly. To put things in context, this year alone, we have welcomed the introduction of the consumer data right. We've seen heightened regulatory activity by both ASIC and the ACCC. The 2020 cybersecurity strategy was released, and we've seen some high-profile breach events, including those against Toll and also the attacks against the Australian government. Significant reforms to the Privacy Act are now also underway. So the train has well and truly left the station. So now is the time to commence a review of the data and privacy related laws that affect your organization. By way of quick introduction, I'm Stefanie Luhrs and I'm a senior associate at Barry Nilsson Lawyers. I've acted as privacy counsel, breach coach and coverage counsel in a variety of cyber matters across all sorts of industries and types of business, including when an insurer is involved. Ben?
Thanks very much, Stefanie. In terms of a very brief introduction for me, my name is Ben DeMarco. My title is Cyber and Technology Risk Specialist with Willis Towers Watson, which is a risk advisory and insurance broking firm. The part that we do is try and help clients understand data and security risks from an end-to-end perspective and work with them across the privacy, the governance, and also some of the risk management and insurance solutions.
Thanks, Ben. So before we delve in, I'll very briefly outline what it is that we propose to run through today. Firstly, we'll take a look at the existing regulatory landscape within Australia. Then we'll dive into some key legislative developments, including the Consumer Data Right, some of the proposed changes to the Security of Critical Infrastructure Act, as well as CPS 234 that came into effect last year. We'll take a look at some of the penalties and enforcement action by each of the regulators in this space, including the OIC, the ACCC and ASIC. We'll highlight some of the key class action activity that we've seen to date and some of the hurdles that have been faced by plaintiffs pursuing those actions. We'll take a look at the threat landscape and some of the incident response trends over the last 12 months. We'll look at the consequences of this changed landscape, as well as some insurance dilemmas and possible solutions. And finally, we'll leave you with some tips for how you can navigate this sea change and what practical steps organisations can implement to address them. So what does the Australian landscape look like currently? Well, I think that any crash course would probably highlight that we have a patchwork of data security laws. So there's no specific overarching cybersecurity act, and the regulatory environment is made up of sector-specific regulations and guidelines, including financial and health regulations, as well as cybercrime and interception laws. To confuse things, there's also a variety of regulators, and regulation tends to differ between public and private sectors, and the types of enforcement action also tend to vary amongst regulators. We have non-privacy regulators adopting a data regulation approach. So the ACCC has been particularly active and it's been successful in actions for misuse of data. ASIC in the last few weeks, it's also commenced its first piece of litigation relating to the obligations of a financial services provider to manage cyber risk. There's currently no standard approach to cybersecurity management, We have the Federal Government Information Security Manual and the NIST framework, for example, but otherwise there is no mandatory national standard for cybersecurity. So with all that in mind, it's not really any surprise, I think, that there are calls for a single regulatory authority as well as a dedicated cyber minister to help to harmonise regulation and standards across both the private and public sectors. The varied regulatory approach means that we've seen quite a bit of activity in the legislative and regulatory space in the last 18 months, and following the introduction of the Notifiable Data Breaches Scheme in February 2018. So this gives you a quick snapshot, and we'll work through these a little bit more. But in July last year, we welcomed the introduction of CPS 234 that applies to APRA regulated entities, and Ben will talk to that a little bit more shortly. But CPS 234 now requires entities to implement certain controls and undertake regular testing, and to also promptly notify APRA of any material information security incidents. The Consumer Data Right, that's a new part of the Competition and Consumer Act, commenced in the banking sector in July, and that will be rolled out economy-wide over time, and the energy and telecommunications sectors will be up next. The 2020 Cybersecurity Strategy was released in August, and that has highlighted some further regulatory change is on the horizon, and that will include amendments to the Critical Infrastructure Act that the government's trying to push out, I think, by the end of this year. Over to you, Ben.
Thank you very much, Stephanie. So in terms of the CPS 234, as has been mentioned, this was a prudential standard that was brought into place by APRA to deal with financial institutions, deposit-taking institutions, insurance companies and superannuation funds. And while this commenced last year, we've now got to the point where those operational provisions have landed, and for many organisations, they're now starting to deal with the real machinery and the real impact of this particular piece of standard. And the three things that we'll really quickly focus on here is that 234 was something that was deliberately designed to be risk principle based. The obligation in a nutshell is that you need to have systems and processes that are commensurate and responsive to the realistic risks that you face as an organisation. This has been a real challenge for lots and lots of different clients that we've spoken to and worked with, and it highlights the dynamic expectations of what APRA have. The two other points that I think are quite interesting is that we do have some transitional arrangements that are currently in place for organisations that outsource their information security and some of their data processing to other organisations, and that's a real focus area for the next 6 to 12 months as some of those types of contracts and arrangements renew and expire, and also with APRA's expectation that those organisations essentially manage their third parties to ensure that the data and their key systems are protected in keeping with the standard. Last 2 points I'll quickly mention here is that we've had a lot of statements from APRA, including from their executive member, Greg Summerhays, focusing on the fact that organisations need to understand their data. They think cyber resilience is a key issue, and also that they're acutely aware of the fact that many organisations that they regulate are experiencing significant data threats. And this is also reflected in the corporate plan, which again highlights the need for cyber resiliency, and that they will continue to work with other regulators to promote this across the financial services network, and will have an increasingly compliance focused in this area. Excellent.
Thanks, Ben. So the Consumer Data Right is a pretty big shake-up for Australia's data regulatory framework. The CDR is a complex statutory regime, but it is basically just data portability reform that enables consumers to request that organisations share their data to third parties via an online system, and where that third party is an accredited provider under the CDR regime. Previously, we had no right to data portability like there is in the EU, so its introduction here is a novel development, and the intention behind it is to boost competition and to improve our consumers' choice and control over the data. The regime is quite complex, so I'll draw your attention to just a few things that I think you should be aware of. The first is the consumer data rules. So the rules currently set out the framework for how the CDR operates in the banking sector, but the rules are intended to be a living, breathing document that will change over time as things develop and the CDR expands into different sectors. But the key things to take note of in the existing rules is a process for consumer data requests, as well as the rules around accreditation. And so the rules set out the process and the requirements for applying to become an accredited person, and also their ongoing obligations. So in the banking sector, for example, an accredited person could be a bank or a fintech that wishes to provide a good or service using CDR data. CDR data in the banking sector currently includes things like transaction data or customer data and customers' account data. At the end of August, the ACCC had received 5 applications for accreditation, I think which are still under assessment, but there are 20 more applications currently in development. The Consumer Data Right is accompanied by privacy safeguards that set out how privacy will be protected and how confidential data will be dealt with under the regime. So the privacy safeguards are similar to the Australian privacy principles that accompany the Privacy Act, but they are broader in scope and much more onerous in some cases. So just because a business may be complying with the Australian privacy principles doesn't mean that it will be compliant with the CDR privacy safeguards. And that's because the privacy safeguards actually cover a broader range of data than the definition of personal information under the Privacy Act. And they also require things like express consent from consumers for the collection and the use of the CDR data, as well as the requirement to keep written records of any disclosure in response to a request. Another thing to note is that the privacy safeguards will actually be enforced under the Competition and Consumer Act, which has a much more extensive penalty regime than what's currently available for any non-compliance of the Australian privacy principles under the Privacy Act. So in addition, CDR consumers will also have a direct right of action for breaches of the privacy safeguards against those that are responsible, and that doesn't appear under the Privacy Act. So any businesses that are participating in the CDR regime will really need to give some thought to how the Australian privacy principles and the privacy safeguards will interact. The CDR is also accompanied by technical data standards that specify how CDR data is to be shared via APIs with organisations accredited by the ACCC. So Data 61, which is part of the government's CSIRO, performs the role of the data standards body under the CDR, and they've developed those standards. The ACCC is the lead regulator for the scheme, but they're supported by the OIIC. And as part of the rollout of the CDR, both of the regulators have jointly published a compliance and enforcement policy, which outlines the approach that they'll take to ensure compliance. And the policy actually calls out certain types of misconduct that will always attract enforcement considerations. So that includes things like refusing to disclose CDR data, collecting CDR data without consent, engaging in misleading or deceptive conduct, and failing to implement appropriate security controls. So without detracting from, I think, what is really a watershed development in Australia's privacy regime, it's probably no surprise that industry has a few concerns with the CDR and its operations. So some of the key tensions highlighted to date include the data security issues with transferring CDR data to a less secure platform. So the concern here is that an accredited person like a bank may be required to transfer its CDR data from what is a relatively high secure environment to a less secure platform if it receives a request from a consumer to transfer data to a comparison site, for example, or a small fintech or broker that may not have the same levels of cybersecurity that a bank spending hundreds of millions of dollars a year might have. Right access is also very topical. So currently, the CDR only allows third parties to access data from banks on a read-only basis, but there's an intention to implement right access, which could allow a third party to change or to add data about a consumer and potentially allow third parties to do things like open and close accounts with consumer consent. So the bank's concern with that is that it will turn comparison sites into facilitators and could potentially allow users to apply for a financial product from the comparison site rather than from the bank directly. Despite competition being the key policy reason for implementing the CDR in the banking sector, some sectors argue that it will only have incremental benefits to competition. So some telcos are arguing that they just don't suffer the same lack of customer switching that you may see in banking, and that any benefits to competition in those sectors will only be marginal. High implementation and ongoing compliance costs is another key concern, particularly in the current economic climate. The energy and telco sectors are up next, and they've voiced those concerns. The implementation of the regime imposes various compliance costs for businesses, including developing new systems and technologies, and the ongoing costs of complying with consumer requests as well. So the costs are really additional costs that many businesses are going to have to absorb, which is going to be difficult in this economic climate. No doubt you'll be aware of the release of the 2020 cybersecurity strategy, and I won't spend too much time on this, but just to briefly summarise, there's obviously a clear focus on critical infrastructure. The government has flagged its intention to expand the coverage of the Security of Critical Infrastructure Act to other sectors like healthcare and education, and to also specify minimum expectations and obligations for critical infrastructure entities. The strategy also suggests that there'll be some legislative reform that will place additional obligations on company directors in respect of cybersecurity. There's no further detail around that just yet, but we could possibly see something similar to APRA CPS 234 that includes express provisions relating to the board's management of information security. A key deliverable under the strategy was the voluntary code of practice for Internet of Things, and that was released on the 3rd of September. The code is based on 13 principles, and it largely mirrors the draft code, but it recommends the use of things like MFA and appropriate identity verification, as well as logging remote access. I think we're still a little bit behind the ball internationally when it comes to that code. The UK has had a similar code in effect for about 2 years now, and it's now looking to move to mandatory security in its IoT products. The Australian government will also work with businesses to consider legislative changes that set a minimum cybersecurity baseline across the entire economy. So the strategy doesn't yet specify exactly what those legislative changes will be, but it's suggested that there'll be changes to privacy and data protection laws, as well as duties for company directors, like I mentioned earlier. And finally, the strategy looks to better assist SMEs by uplifting their cybersecurity capabilities. The government intends to provide SMEs with bundles of secure services that includes things like awareness training and threat blocking. They also intend to expand their 24/7 hotline out to SMEs.
Thank you. So just continuing with the next topic, Steph has already mentioned that we've had some focus around the critical infrastructure space, both in the cybersecurity strategy. And one of those areas of focus is also in terms of having amendments to the existing Critical Infrastructure Act of 2018. This act in its initial guise was really about identifying who owned critical infrastructure assets, encouraging information sharing, and also promoting some form of resilience where we had events. The three areas that the Australian government has indicated they're looking to amend and that they're looking to strengthen, firstly in terms of creating positive security obligations, which can have both a cyber focus and a non-cyber focus. So in terms of these positive security obligations, these are both designing sector-specific responses, approaches to physical security, approaches to training. And in terms of specific cybersecurity obligations, a key thing that's been mentioned here is that for many of these organisations, they need to get better in terms of developing playbooks. They need to do more of what the government is calling cybersecurity exercises. So whether that's internal examinations, external audits, certain types of scenarios or tabletops, and also that they want there to be a much more proactive approach in terms of how these organisations understand these obligations and also the role of boards and senior management. And the third thing that they're looking to amend is government assistance, so essentially making it so that organisations will be able to communicate more effectively with government and also allow government to become involved and to provide assistance where there's a very significant cyber threat, or alternatively where there's some type of cyber incident or some type of cyber concern which may have a wider sovereign or economy impact.
Thanks, Ben. So as to the types of penalties and enforcement action in the last 12 months, we've seen the ACCC be particularly active. It was recently successful in securing a $2.9 million fine after the federal court found that Health Engine, which is a GP booking platform, had engaged in misleading conduct by sharing the personal information of patients with private health insurance brokers. The ACCC has also commenced 2 sets of proceedings against Google. In late 2019, it commenced an action against Google claiming that it misled consumers about the circumstances in which their location data is collected and how to opt out of that. That hearing's scheduled for November this year, and Google said publicly that it will defend those claims. The most recent action against Google alleges that it misled consumers by failing to adequately disclose changes to its privacy policies and the way about that personal data is collected and used, but that's still in its very early stages at this point. ASIC recently commenced litigation against RI Advice, which is a financial services company, alleging deficient cybersecurity practices. ASIC claims that RI breached its AFS license conditions and failed to discharge its duties and functions by failing to implement adequate systems, resources, and policies. And although ASIC's had a heightened focus on cybersecurity in recent years, this is actually the first time that ASIC has commenced legal proceedings alleging deficient cyber practices. So ASIC has indicated in the past that managing cybersecurity risks falls within the realm of general director's duties, but in this case, ASIC's claim against RI Advice actually alleges contravention of its obligations as an Australian financial services licence holder, as opposed to a breach of its director's duties. So the RI litigation, I think, is a shift from ASIC's focus from just education to real enforcement, and it's sending a strong message that ASIC is taking deficiencies in cybersecurity very seriously. We haven't yet seen any enforcement activity by APRA for non-compliance with CPS 234, but the OIIC has recently commenced a joint investigation with the UK Information Commissioner to invest Clearview AI's privacy practices. You probably heard about this matter. Clearview is a technology company that allows a user to take a picture of a person, upload it, and then identify publicly available photos of the individual, and it sources available photos from things like Facebook and YouTube. The OIC has stated that it won't comment on that investigation, so we don't yet know if it will lead to enforcement action, but I think it seems likely. The OIC's attention has otherwise been focused on its landmark litigation against Facebook arising from the Cambridge Analytica scandal. So the case against Facebook is particularly significant. I'm sure most of the audience will be familiar with the Cambridge Analytica scandal that relates to the harvesting of personal data of Facebook users by an app, which was then on-sold to Cambridge Analytica, who used that data to produce a targeted political campaign. Only a small number of Australians, 53 according to the OIC, actually installed the app, but the app was able to obtain the personal information of a further 311,000 Australians who were friends of the 53 users. So the OIC's key issue with this is that Facebook's privacy settings were so opaque that the processes for changing them were so complicated that most users wouldn't have realized that the app could access their data by default. Facebook hasn't actually been able to precisely state the personal information that was accessed by the app, and it's also not known if any other third parties access the information. So there are a few reasons why these proceedings are particularly interesting. Firstly, there's a question as to whether information can be personal information within the meaning of the Privacy Act if the identity of the individuals whose privacy has allegedly been interfered with isn't known to anyone. Because the Commissioner isn't able to identify with any precision the identities of all the Australian individuals and the particular information allegedly collected and held about them, it's possible that the court could conclude that the information is not in fact personal information. Secondly, it involves overseas companies, so the court will have to consider whether the Privacy Act applies extraterritorially, which will set an important precedent for businesses that operate from offshore. And thirdly, the OIC is seeking a penalty for each disclosure of personal information by Facebook, which constituted an interference of privacy, and that will have a major impact on the maximum penalty available. If each person affected is said to have had their privacy interfered with, then there could arguably be 311,000 instances of an interference of privacy to consider in formulating a penalty. And if that's accepted by the court, Facebook could be potentially liable to an extremely large penalty. The maximum penalty for a contravention at the time was $1.7 million. So instead of a $1.7 million fine for a single interference, the penalty could potentially be as high as $500 billion. So the determination as to whether the disclosure by Facebook is multiple or a single interference with the privacy of an individual is going to set an important precedent for calculating the quantum of future penalties under the Privacy Act.
Great, thank you very much, Stephanie. I've seen a question that we've had pop up in the chat room, and yes, we will be making these slides available. Also, Steph and I have taken the typical lawyers approach where we've probably given you enough content for 2 sessions. So I'm going to cover a couple of my slides very, very quickly because we really want to have questions and some discussions with you at the end. The next slide that we're going to is ACC v Health Engine. I'm sure a lot of people are aware of this. This is a piece of litigation that was filed by our competition regulator. And what it focused on was misleading and deceptive conduct by Health Engine in terms of how it was using patient data, how it was communicating, referral data, and also the way in which it was sharing it with third parties. There has now been a fine that's been entered and that's been accepted by the court for $2.9 million. There's 2 things that are very significant here. Firstly, this fine also has reference to the benefit that Health Engine obtained as a result of its conduct that infringed the Act, and specifically it incorporates the amount of referral revenue that was obtained and also the way in which the data was used financially within the business and within the organisation. Secondly as well, what we're also seeing is that we're now seeing different regulators coming to play. By having these different regulators, the types of risks that the organisations have to think about is changing. And also we have to think about as well all of the public statements and all of the different things that we say about how we're using data and how we're using information systems. I think this one's yours, Steph.
Thanks, Ben. So as to data breach class actions, I think the tide is turning, but organisations still face a number of hurdles. And to date, we've only seen 1 data breach class action receive any judicial commentary before the courts. That case involved a class action that was commenced by 130 ambulance employees against the New South Wales ambulance service after employees' workers' compensation files were sold to personal injury law firms by a contractor. The case was settled and it was brought before the courts to determine if the settlement was fair and reasonable. So there's still no judicial commentary around the legal causes of action that can be pursued for a data breach class action. The key difficulty in Australia is that there is no statutory right to make a claim for breach of privacy, and there's no tort of privacy under the common law either. There's also some difficulties with quantifying the loss claim for data breach class actions. So the problem is that claims by affected individuals are often for distress or embarrassment and not actual financial loss where there's been unauthorized access to personal information. So the calculation of that loss or even the potential value of the data is particularly difficult to quantify, and there's no agreed method. And in some cases, it may be relatively straightforward if there's been direct financial loss from something like a fraudulent transfer of funds, but in most cases, it's not clear cut and there's no Australian precedent.
Great, thank you, Steph. So again, mindful that we want to have some questions, I am going to burn through these next few slides. We wanted to give the audience an idea of what we were seeing in the threat landscape, and what I've put up here is 5 points that we're consistently chatting about with our clients and that we're finding clients are grappling with. 2 things I'll quickly focus on here is we do think incident response is changing, and in this post-COVID landscape that we're in, we're seeing a lot of clients facing difficulties in terms of how they coordinate themselves internally, how they get the right vendors and how they onboard the right vendors quickly, and also how they manage the communications and manage stakeholders when we go through the incident response process. The second one that I'll focus on is what's happening in the extortion and ransomware space. We're seeing a lot of organisations, both here and globally, facing increasing ransoms. I can tell you from our experience, we're aware of multiple that have happened in the last few months where the ransom amounts have been 5 million plus. We're also seeing very different forms of extortion. So extortions that focus not so much on allowing you access to data to restore systems, but rather the publication of sensitive data if you don't pay, or alternatively that sensitive documents or sensitive information that's been harvested from you will be misused in a way that causes damage. So the next thing we really wanted to talk about was Landmark White, and I'm sure many people here have looked at the case studies. They're relatively aware of what's happened with Landmark White. But the thing that we think is very, very interesting is Landmark White is a matter where obviously there was an immediate impact to the business when it had a cyber event. The banks that it worked with suspended it from their panels and there was a significant financial loss. But there's also been a very long-term shareholder loss and a very long-term business reputation and business interruption loss. We're showing you a slide that tracks what the Landmark White share price did in the 12 months following the data breach and the public announcement of the data breach. And you'll see that there are a series of significant drop-offs that relate to negative events that the company sustained. But even more interestingly, if you track it through to the next 12 months and the period where we currently are, that share price hasn't really recovered and it hasn't really rebounded. And I think this is one of the things we've also got to think about in terms of how the landscape is changing, that we now have evidence that significant cyber events have very long-term risks, they have huge reputational impacts, and we have to have a very end-to-end approach in terms of how we manage them and how we deal with resilience. In terms of some of the consequences of the changed landscape, we do think that there's now a very strong connection between cyber events and BI and financial loss. We're seeing now organisations have less redundancies. We're seeing a huge technology dependency for anything that's revenue generating. We're also seeing for our clients the need to go beyond personal information and PII. For a lot of our clients, it's really about what's happening with their corporate data, the data that the systems rely on, and also what's the type of data that is really the crown jewel assets. Two other things I'll very quickly mention here is that we are seeing a strong focus in terms of organisations that sustain significant data breaches, thinking about what they can do to maximise financial recovery. This can be both through insurance, which hopefully is robust and has been comprehensively designed, but also potential legal recourses. So against service providers, against supply chain partners who might have caused the breach. And finally, we're also seeing a real focus now on understanding that each organisation has pretty unique risks. Even across industries, the tolerances will be different, the key drivers will be different, and we've got to really think about that first point of how is data being used and how are systems being used. Insurance solutions, I just want to cover this very, very quickly, but we are finding for a lot of organisations they have to really carefully look at their insurance at the moment. It's really critical that you have affirmative cyber insurance policy or product. The market is essentially taking out covers from traditional insurances, so property, ISR, public liability, kidnap and ransom, and there are a number of new cyber exclusions that are coming in. Part of this is because that the insurers have realised that this is a casualty risk. The amount of losses now are very, very high. We have multiple examples of incidents where there's multiple millions, in some cases 10, 20, hundreds of millions following cyber events. And finally, by extension, we need to have a really robust discussion with clients to make sure that we tailor insurance to what they need. So we're coming to the end, and just in terms of things that you can do, we think that there's a good reason now to be focusing on data governance processes, what we're doing from cradle to grave, but also making sure that in addition to understanding systems and having policies that are done by the information security people or by people that are at the coalface, that there's that wider governance support. So whether that's through internal committees, whether that's to the board, and that whole governance picture is becoming a huge focus of regulators. We also think that the regulatory risk is changing, so organisations need to assess this, they need to think about it, and we're seeing very significant changes in the contractual risk space too, both in terms of assumptions of liability, limitations, and affirmative obligations. For policies and frameworks, we're finding many organisations are having to review these carefully, and even if you had something that worked pre-COVID, we're finding with our clients that they actually don't work very well in the current environment. Finally, obviously, collaboration and information sharing is a huge focus for the government and also I think will be very important for industries and organisations. And insurance and resilience strategies. One of the most common things we're seeing is an acceptance by organisations that they will have a number of data breaches. So we need to make sure that there's a recovery aspect and that the organisation can be as resilient as possible. That's all from me. So we're very happy to take questions. You can either raise your hand and throw things at us, or if you want to just put some things in the chat, and Steph and I will just address them as they come through. Vladimir, you're just on mute.
Sorry, my apologies. There's a couple of questions in the Q&A if you'd like to try and address those.
Fire away. Okay, so we've just seen the questions. So do you know if some universities will be more impacted by critical infrastructure such as those that tie to the Defence Force? Two things I can say there is there will be some impacts because the way the government is talking about the critical infrastructure legislation, it will extend to third parties and it will extend to the various suppliers and organisations that work with a critical infrastructure provider. So we do expect there to be that expanded effect and that type of ripple effect. We've seen another question that's come through. Do you anticipate the ACC will extend the CDR to effectively enforce strong separation of back-end and front-end services, e.g. Consumer operations under ADR and similar requirements? Did you want to have a first crack at that, Steph?
I think it's pretty hard to know at this stage. I think it's still very early days, and that the ACCC is still trying to work through with the banks the current operation under that scheme. So I think watch that space, and you'll probably see a little bit more activity in the next few months, I think, as things start playing out.
Yeah, the only thing I would add is if you look at how the ACCC typically behaves, it can be sometimes a bit of a blunt instrument. So I think when it decides what the framework is and what the obligations are, they're probably going to be applied quite uniformly. And I'm not sure if you're going to see distinctions or lower standards being implemented in an ad hoc fashion. Do you have any other questions, comments? Well, I guess just in terms of a closing comment from me, thank you obviously everyone who's been involved and listened to this talk. Obviously there's a lot of material in the slides which is very, very dense. We'll be sharing this with you. But if you have any other things that you don't understand or questions, please feel free to reach out to Stefanie and I either by email or in chat. We're always very happy to share information and have a chat with people on issues that are of interest to them.
Great. Thanks, Ben and Stefanie. That was quite informative, updating us on what's going on in Australia at the moment.